Good afternoon, everyone. Thank you all for coming and listening. It's always hard to be in a panel post-lunch. It's even harder to be the person just before the coffee break. So as Mr. Nag said, please go and grab your coffee. Thank you so much to NCAER, Dr. Shekhar Shah, Dr. D.B. Gupta, for inviting me to participate in this conference. Thank you, Mr. Mandan, for starting us off with your very informative and instructive presentation. And Mr. Nag for chairing, and Mr. Anderson for your insightful comments. So I'm actually here today because my colleague Dr. Partha Mukhopadhyay, who was scheduled to speak, could not make it at the very last minute. And so I was asked to fill in for him. So not only do I have tall shoes to fill, because if you know Partha Mukhopadhyay, you know I mean this literally and metaphorically. But also because Partho is an economist and I'm a lawyer and legal academic, I will probably offer a quite different perspective from what he would have provided if he had been here today. So apologies in advance if what I say is not what you expect. But I have been working on land rights and property rights issues for several years now, both as a lawyer and legal academic. I started the Land Rights Initiative at the Center for Policy Research last year. We'll complete 1 year in November. And some of my colleagues are actually here today as well. And I'm currently working on a book on land rights in India. So hopefully what I will say will be relevant and helpful for the questions we are interrogating here. I plan to offer 3 sets of remarks. In the first set, I want to present a lawyer's understanding of property rights and land, which often I find is at variance with those of economists, development theorists, and now based on Mr. Mandan's presentation, also investment risk analysts. In the second part, I would like to speak about the differentiated legal regime in India with respect to land rights. And here I'll draw upon my doctoral work, which traces the history of the constitutional right to property in India, as well as the work that we are doing in 2 projects at the Land Rights Initiative on land rights in the scheduled areas of India, and a project on land conflicts where we are studying all 2,500 cases decided by the Supreme Court on land acquisition. And in the third part of my remarks, I would like to share findings from some recent research on the project finance market in India, which shows essentially that there are really very few legal obligations on the biggest players in the market to conduct social and environmental impact risk assessments before they clear loans for industry and infrastructure projects in India. So let me start with the lawyer's understanding of property rights. And here, my remarks are framed in response to a paper by Mr. Mandan that was sent to me just last night before the conference. But it was very instructive to hear your thoughts as you presented them now. And I found many points of agreement between what you said and what I myself believe, especially when you said that I wholeheartedly agree with you that it's not enough to attract investment, we have to have the right outcomes. But in the paper, the earlier paper that I read, you started off by arguing that various investors in industries are incurring substantial risks and costs because they don't understand that property rights in emerging markets are dysfunctional to the point that ownership can be granted to an investor without the tens of thousands of people living on it or dependent on the land not knowing it. And that was one of your key messages today as well, that there are pre-existing claims of populations on land. Now, there are various concepts in this sentence which I would like to clarify from a legal perspective. First, what is property? Property is understood by lawyers to essentially mean a bundle of rights. It's not a thing, it's really a bundle of rights of different people with respect to a thing, which include the rights to title, but also use, possession, mortgage, sale, and inheritance. Rights to title, inheritance, and sale often constitute what we call, in common parlance, ownership. But there can be many subcategories of title and use and possessory rights, all of which are also separately transferable through sale and mortgage. The bottom line, therefore, is that property does not constitute ownership, and that ownership is only one right amongst many. Ownership or title is only one right amongst many. Therefore, if the ownership of land or title to the land is transferred, then that doesn't mean that other property rights have been transferred. And that is not evidence of a dysfunctional property rights regime in an emerging market. It is true of property rights regimes everywhere in the world. I'll give you a few examples to illustrate this point, but before I do that, let me make two further points. My second point is that once we understand property as a bundle of rights, it is impossible to deduce from the concept of property itself what this bundle of rights would be for different people in a different legal regime. In other words, there is no such thing as a functional or dysfunctional legal regime governing property rights, and so investors and business interests need to understand in great detail the legal regime of the particular country that they're investing in. They cannot imagine that property rights in emerging markets are cookie cutter identical. The third point is that we must not forget that property rights are never absolute. They always come with regulatory obligations that are imposed by the state to balance the rights of the individual with respect to that property with the interests of the community. In other words, the social interest in that property. These regulations include, for instance, zoning laws, as well as tenancy protection legislation. So now let me give a few examples to illustrate these points by reference to some examples from the developed world, countries that I've lived and worked in, the US and Norway, and which, based on the case studies that Mr. Manan discussed in his earlier paper, are home to investors in various emerging markets. One of the examples you gave was of a Swedish investor, and others are by American companies as well. Now, at the beginning of my legal career, I lived and practiced law in New York City, where apartments in many buildings come under rent control legislation. What this legislation does is it restricts the rights of owners of those buildings or apartments to raise the rents of their tenants or to evict tenants from those buildings whose rents were frozen in time and so they can't really evict an existing tenant whose rent has been frozen in time to get a new tenant to live there. My next door neighbor, an elderly lady in the same building that I lived in, paid half the rent that I paid. And I obviously paid the market value of the rent. And this was because she had lived in the apartment for 30 odd years, and that was frozen in time by the rent control law. So clearly, in such cases, even in countries like the US, the owner of the house can only sell his house subject to the claims of the tenant whose rights are protected by the rent control legislation. In that respect, this situation is not very different to where the private investor of the land acquires land from the legal owner of the land in India, or where the government acquires land from the legal owner of the land in exercise of its powers under the Land Acquisition Act, say, of 1894 and now the new act, and transfers it to a company. What the government or this private owner has done has only transferred rights to title. But as in the rent control legislation, he has not transferred the rights of the tenants. So the land that is transferred is always subject to the encumbrances of the rights of the people who are dependent upon it. Now, unfortunately, in the case of India, the Land Acquisition Act, which is the Colonial Act of 1894, recognized the rights only of land title holders and not those who were dependent upon the land for their livelihood. These people, who are now described as livelihood losers, included people like sharecroppers and tenants who were working on the land, but also groups with rights over common property resources like cattle grazers, fishermen, forest dwellers, and indigenous tribal groups. So grave injustice was built in already into the process of land acquisition, and this injustice was made possible because the 1894 Act was a colonial enactment. It was enacted by an unaccountable British Parliament, and because this was continued by democratically elected post-colonial governments who used their powers under the Land Acquisition Act to transfer title to the land to government and private companies for public purposes, largely for dams, infrastructure, and industry. And it was really interesting from your presentation how you show that most of the conflicts are in these areas. Now, this was the case until the repeal and replacement of the 1894 Act by the 2013 Land Acquisition Act, which for the first time has recognized the rights of livelihood losers who must be compensated upon the acquisition of land. This wasn't something new. This was a recommendation that was made by the Law Commission of India in 1958. It has taken 60 years for us to implement it. Now that brings me to the common property resource rights that are often asserted also as an anomaly in the developing countries. But the truth is they're also a ubiquitous feature of the developed world. For instance, if we take an example again from an urban setting, parks in the US are places where communities have rights. You just can't take away the park and give it to an industry, but that is done in emerging markets sometimes. Also, when I lived in Norway as a research scholar 2 years ago, and Norway, of course, is a very green country. There are plenty of wooded area available for hiking. Any member of the public can basically pick off forest produce, like berries or flowers or whatever. Not only that, I once went for mushroom picking with my colleagues on a private farm, and it turned out that we were not there by permission, but as a member of the public, I had a right to pick off wild fruit or vegetable from that land. So, in other words, even if this particular landowner, it was not if he sells his land to person B, he could prevent us from picking off the wild mushrooms. No, he can't. It's subject to the right of the public to do that. So there is, in other words, and Norway was a colony of Sweden for 200 years. I cannot imagine the legal regime in Sweden would be that different. So, in other words, these investors who are coming from these countries should be familiar with these common property resource regimes that are available in their countries as well. So, I guess the first point to conclude this part of the presentation, the first point I want to stress is that land markets in emerging countries are not fundamentally different from investment environments in the developed world. I disagree also with the idea that emerging markets lack formal property rights. They don't. Because, as I've just explained, use, possessory rights of tenants, sharecroppers, forest dwellers are legal and legitimate rights. And they are protected by a plethora of legislation in, for example, India, but also other countries. Now, some of these rights, for instance, the rights of tenants, who are the people who are actually cultivating the land, have been protected by tenancy legislation in India, starting from the British times. In fact, there was a lot of conflict following British colonization and the creation of the zamindari and other systems of land revenue. And at some point, the government had to step in and protect tenants' rights as well. So their rights are protected by law. The rights of other communities were systematically de-recognized, like the rights of the forest dwellers, by the colonial government, but they have also now been recognized pursuant to the 2006 Forest Rights Act. What is, however, different between the developed world and emerging markets or developing countries is that we are going through a transition from a feudal agrarian system of living, which is also coexisting with traditional and pastoralist occupations. We are undergoing that transition to a capitalist industrial form of governance, a transition that the developed world has already gone through. The difference is that the developed world made this transition over a period of hundreds of years. And they went through the same kinds of conflicts that we are going through today. For instance, the enclosure movement in the United Kingdom during the 18th and 19th centuries helped to decimate substantially common property rights and over land and make it privately owned land. But developing countries are making these huge transitions over a period of 50 odd years. Most of the countries in emerging markets have become independent only the last 50 odd years, and that's where development theory also starts. It starts in the post-war period. The idea that, by following particular theories or following particular instances and models, we can actually bring about development. Now, transitions are always difficult and produce conflict. When they happen in a very compressed period of time, that conflict is intensified. So, of course, investors should be aware of the huge risks involved in any kind of land transaction in developing countries with existing sets of rights and entitlements based on the experience in their own countries and the realization that the transition that is happening at a breakneck pace compared to what they underwent themselves. That they are not aware of that seems rather naive to me. And so, of course, the first explanation is that they are naive. And based on what Mr. Anderson was saying, it seems that often investors are really clueless about how to sort of deal with with the populations that they are investing their resources in. But the other explanation, so one explanation is that they are naive. The other explanation, of course, is that they have tended to ignore these risks, that they were aware of these risks, but they've tended to ignore them because the larger political economy and the asymmetries of power between government and other stakeholders in these emerging markets have in the past enabled them to do so. So you don't worry about the population. And in India, this is particularly interesting because we didn't have a lot of foreign direct investment pre-1991. So most of the investors, and I'll come to this in the last part of my presentation, the project finance market in India has overwhelmingly dominant local participants. It cannot be assumed, I would not like to assume that these people with the best and brightest brains advising them would not be aware of these risks, which means that they're tending to ignore them. Nevertheless, based on what I've said, I think it's clear that we cannot strengthen, clarify, formalize property rights without becoming entangled in economic, social, and political struggle. It's just impossible. Even if you go ahead and formalize land record systems, and I know that the Department of Land Records is trying to actually do that, it is going to be a conflict-laden process, and I do not expect the conflict to end once this process is concluded. Any expectation that government or industry can bypass this political economic struggle is misleading. There is no ideal form. Property merely expresses a distributional outcome at a particular period of time in a particular context, subject to change and contestation. So with that, I conclude the first set of my remarks. The second set, which was about risk in India. And here I'll take Mr. Nag's invitation to talk a little bit about my work and the insights from that. So I would like to briefly outline what an investor should be prepared for when planning to buy land in India. And again, here, for an investor, land is an asset. As a lawyer, I think of land as a resource. As an anthropologist studying communities who have a very emotive connect with the land, for them it could be culturally so significant that it is not a resource or an asset. It's really something that gives them their cultural and traditional identity. But taking my definition of land as a resource, what should the investors be thinking? India is both geographically and numerically vast, more akin to a continent than a country. So it really doesn't make sense, first of all, to speak of India as a whole. This is especially the case with land, because within India's federal constitutional system, land is a state subject, which means that state legislatures have the power to make laws with respect to land, and this has historically been the case since British times, because we didn't fundamentally rework things within the constitutional framework from the Government of India Act. So the first point is that there will be differentiated legal regimes governing land in different parts of the country. Gujarat is different from Tamil Nadu, is different from Andhra Pradesh. The second point is that there are often conflicts between central and state laws, because while land is a state subject, acquisition and requisitioning of property is a subject in the concurrent list, which means that both central and state legislatures have the powers to make laws for land acquisition. As a consequence, we have hundreds of laws of land acquisition, not just the 1894 Act or the 2013 Act, causing quite often conflicts between laws. And as I said, we've just started this work of studying these 2,500 Supreme Court cases on land acquisition conflicts. And we find that many cases are actually about litigation involving both central and state laws. So there's the 1894 Act, which sets compensation at a certain level, and there is a state law which sets compensation at a different level. And we find that the state is basically applying different laws to different parts of land in the same area. So because state can pick and choose a law, and that leads to conflict, because A goes to court saying that why should I be paid less compensation under the AP Act when I should be entitled to more under the 1894 Act, and my neighbor B is getting more compensation under the 1894 Act. So and in this context, I think the move by the current government, they've been announcing that they want to now leave land acquisition to the states. It may be a politically expedient move, but if they think that through this the deadlock will be magically resolved, I think that they're going to be disappointed. The third point is that there is a different regulatory regime governing the uses of land, and the Honorable Minister mentioned that when he was here, agriculture or industrial use. And there are restrictions on sale of land without such conversion, which also produce conflict. So typically what happens is that a farmer who sells his land because it is for agricultural use at a certain price, then when the government, he may not sell the land may be acquired at a certain price, and then the government converts the use of the land, and when it becomes industrial use, the market value immediately goes up and then sells it to the industrialist, and the person who has sold his land at a much lower value is left completely disappointed by the transaction as it happens. So that's another regulatory regime that needs to be looked into, the land use regime. The fourth and final point I want to make is about the scheduled areas in India. Now, as I mentioned earlier, we are working on a project on land rights in the scheduled areas. What are the scheduled areas? These are areas demarcated in Article 244(1), read with the 5th and 6th schedules of the Indian Constitution, hence the name scheduled areas. These areas are subject to a completely different legal and administrative regime as compared to the rest of the country, what you and I are used to sitting in Delhi. The 5th schedule provides for the administration of tribal majority areas in 9 states within peninsular India that have tribal minority populations. That is, the population of the scheduled tribes is in a minority compared to the population of the remainder of the state. Now, amongst the 5th scheduled states, we are looking at the states of Gujarat, Andhra Pradesh, and Telangana. The 6th schedule provides the broad framework for the administration of tribal areas in the northeastern states of Assam, Meghalaya, Tripura, and Mizoram. Now, the legal regime governing land in these areas is completely different from the rest of the country, as many of the industries like Vedanta discovered when they started work here, and that's also one of the case studies that you looked into. Extractive industries like mining, and here Mr. Anderson's comments make a lot of sense. miners can only go where the mines are. And in India, a lot of the mines are actually located within the scheduled areas. Extractive industries need to be particularly mindful of the differences in these legal regimes, precisely because because the scheduled areas are where the mines are. So I know Mr. Nag was very generous and he said I could take more time, but I think I will now move to the third part of my presentation, and if there is still some time, then I could expand more on the work that we are doing.
No, I think just wrap it up and then we'll come back to it, Namita.
Sure. So here I want to share findings of a recent study that I completed on banks' failure to conduct environmental and social impact assessments while deciding to give loans for projects in India. So to give you some context about the project finance market in India, in 2014, India ranked 4th in the world project finance market, and infrastructure investments accounted for 14% of the bank's asset books. Now, this is a market, as I mentioned, with overwhelmingly dominant Indian participants. The State Bank of India has a lion's share. In 2009, it had 67% of the project finance market, followed by various private sector banks like ICICI, IDFC, Axis Bank, and also a government bank, IDBI. Foreign participation is very limited in this market. But we do have significant participation by multilateral financial institutions like the World Bank, the ADB, and the IFC. Now, the MFIs do have environmental and social impact assessment frameworks based on their monitoring and evaluation reports. They have, however, noted several shortcomings, and Mr. Anderson was referring to the IFC principles that the IFC does follow. Now, for instance, talking about the ADB, an ADB report has found that in implementation of whatever frameworks they have in India, they find that local communities have a limited role with regard to mitigation. There is consistent use of previous environmental plans without critical review, and social impacts and environmental monitoring has been inconsistent with ADB projects, if not deficient. On the private sector side too, IFC, as I said, has developed these principles and policies, which they have to follow in lending to private sector banks in India. But the only bank in India which has, first of all, IFC funding again is limited in terms of the share of the project finance market. And finally, in 2003, a group of Western private sector banks adopted the Equator principles that were primarily intended also to provide a minimum standard for due diligence to support responsible risk decision making. These Equator principles prevent financial institutions which have adopted them from providing project finance or project-related corporate loans to projects where the client will not or is unable to comply with the Equator principles. To a great extent, these principles are essentially attempts by private sector banks to incorporate the IFC standards and make them applicable to lending by private sector banks in India. In India, IDFC is the only bank to have adopted the Equator principles, and it did so only in 2013 and has submitted only one report of compliance with these principles. But as I mentioned earlier, the vast majority of Indian project finance deals are arranged by Indian banks where there is no regulatory mandate to adopt these standards. In 2007, the RBI issued a circular which said that the banks should take into account these principles, but there was no mandate. Also, what we found based on our interviews with the foreign banks who were operating in India, and of course these interviews were anonymous, they are not necessarily conducting the environment and SIA risks in accordance with their mandates in India. So, to conclude, since it would be in the bank's own self-interest to apply these principles, and our interviews revealed an awareness of this issue, it is curious why they are not doing so. The answer lies perhaps, as I suggested earlier, in the larger political economy of land deals in India, which has in the past enabled investors to get away with managing land conflict through extra legal means, but as the rising number of non-performing assets in these banks relating to project finance indicates, it may no longer be the case now. Thank you.